Okay. Hello and welcome everyone to Untangling 2026 Privacy, New Laws, Amendments, Enforcement, and more. 2025 was a complicated year in data privacy, and 2026 promises to be more of the same. So we're going to have this webinar and hopefully help you feel a little bit more prepared for compliance in the new year. So today I'm joined by Shelby Dolen and TK Lively from Troutman Locke. Shelby and TK, why don't you introduce yourselves?
Thanks, Matt. Hey, everyone. I am Shelby Dolen. I am a privacy and AI and cyber associate based out of Denver, Colorado. And my specialty really is in US state privacy law. And I also have expertise in children's data privacy law, and really looking forward to being here today. This is our third year in a row with Osano. So, three-peat, we're very excited.
Yeah, and just to echo Shelby, thanks everyone for joining us, and excited to be here 3 years in a row, well, 2 for me. But my name is TK Lively, and I am also a privacy and cyber associate at Troutman Locke, based in Denver, Colorado, and excited to be here, talk privacy about privacy laws with you guys.
And I'm Matt Davis. I'm the marketing content lead here at Osano. We always love having Shelby and TK on for these, new year, new laws webinars. It's always kind of a scary time at the start of the year, right? You just come back from the holidays. It feels like your brain's had a big reset, and suddenly state regulators are saying you need to comply with X, Y, and Z. So hopefully today we can help clarify some of the confusion and make your lives a little bit easier. So the agenda, we're going to start off by talking about what happened in 2025, what the data privacy landscape looked like, what major developments occurred, what the new laws went into effect, and so on and so forth. And then we're going to move into 2026. It's not exactly looking ahead since we're in 2026 and some privacy laws have already gone into effect, but we'll cover those as well as whatever is to come in the coming months. Then we'll talk about enforcement. There's no data privacy webinar that's complete without a discussion of enforcement. I know it's the scary topic and it's the one that people want the most insight into. So we're going to cover the things that happened in 2025, notable actions, as well as what regulators have signaled as being their focus in 2026. Then we're going to move into practical tips, privacy program prioritization, which is a lot of P's, but basically we're just going to talk about a few actionable things you can do to reduce your risk in the new year. And of course, we're going to answer any questions that you might have to the best of our ability. There should be a little Q&A tab on the right side of your screen. So if during the content of the presentation you find yourselves with any questions, just chuck them in there and we'll work through them at the end of the webinar. Okay, let's dive in. We wanted to kick things off with a poll to kind of get a sense of what's keeping you up at night when it comes to 2026 compliance. So that might be a lack of budget and resources. You could feel unprepared for this increased rate of enforcement that we've started to see. Maybe there are major gaps in your program that you're aware of but haven't gotten around to plugging yet. There could be a lack of visibility into whether the rest of the organization is following the policies you've set. And of course, you might be a bit concerned, very understandably, about the rapid adoption of AI when perhaps you haven't had the chance to mitigate all those risks. And I know that might not be an exhaustive list. So if you're concerned about something that you haven't been able to, that you don't see represented on this poll, just share it in the chat. Yeah, would love to get some insight there. So I'm seeing right now a tie between lacking budget, staffing, and resources, which is a perennial challenge for privacy, I know, as well as lacking visibility into whether the organization is following policy, which makes a lot of sense. You spent a lot of work on this stuff, and it can be kind of discouraging if you're not sure if your colleagues are doing their best work here. Shelby and Dolen, what do you all think about these results?
Yeah, I think this kind of aligns with what we're seeing with our clients. A big part of it is, getting the right amount of budget, and a lot of that is the first step of understanding the risk. So hopefully we can help you all with that today. But yeah, this completely aligns with what we're seeing.
Yeah, agreed.
All right. Well, I know that's a big challenge, budget, staffing, and resources. It seems like we're always kind of shouting into the void there. But yeah, knowing the landscape, knowing the risks, knowing what the workload is going to be like is a big step towards arguing for those resources. So let's move into kind of our retrospective of what happened in 2025. Last year was kind of a high watermark for data privacy in the US. There were 8 individual privacy laws that went into effect. That was Maryland, Minnesota, Tennessee, New Jersey, Nebraska, New Hampshire, Delaware, and Iowa all went into effect in 2025. So, and in contrast, 2026, there's only 3 laws that have gone into effect this year or will go into effect. And we'll talk about those a little later on in the presentation. But I mentioned this because it's kind of represents this ebb and flow in privacy. We had so many laws go into effect last year that now regulators and enforcers are pretty eager to make use of the new tools they've been given. And Shelby's going to cover a lot of the enforcement actions that we've seen thus far in depth later. Another factor to consider here is the risks aren't just isolated to individual jurisdictions, right? If you have if you get the attention of the regulator from, say, Minnesota, for example, it's not just the Minnesota regulator you need to worry about, because all of these attorney generals, they talk to one another, they work with one another, they learn about the sort of issues that they're seeing, and they're investigating in a cross-border, cross-state fashion. So it's really a case of the whole being more than a sum of its parts, unfortunately. But to that end, there's we're not going to be able to cover every single law that went into effect over the course of 2025, but we did want to call out a couple of highlights. So Minnesota's law, the MODPA, is maybe the most unique law in the US, I would say, out of all of the state privacy laws. That's because of certain outright bans on activities that it presents, regardless of consent. So if you want to use sensitive PI for an unnecessary purpose beyond beyond delivering a product or service to the consumer, you're not allowed to. Even if you notify that consumer and say, hey, do you mind, can we get your consent if we use your sensitive information for another reason? MODPA says, no, you can't do that. Similarly, any sales of sensitive PI not permitted under that law. PI collection in general, limited to only what's reasonably necessary and proportionate for delivering a product or service for that consumer. Again, consent here doesn't matter if the consumer says that's okay. You need to really kind of right fit it to what you're delivering there. Additionally, the MODPA has a requirement for you to, whenever you're running a PIA, is to run that PIA for each algorithm that's involved in the thing that you're assessing, which is kind of a vague requirement that could get very onerous depending on how strict it's going to be. So that's just a few of the characteristics that make Maryland's law a little bit more of a beast compared to the other members of its cohort in terms of the privacy laws that went online in 25. Minnesota, also a pretty unique law, the MCDPA here. It has some fairly uncommon rights relative to other state privacy laws, including the right to request a list of third parties who have received the consumer's data, and the right to question the results of profiling. When you hear profiling, that's mainly about automated decision-making technology and AI, essentially. So more laws are getting amended to include rights around AI, automated decision technology, and profiling. But the MCDPA is one of the few that came out right on the gate with that requirement. It also requires the creation of a data inventory. You might hear this described as a data map. This is essentially an inventory that lists where you got your data, where it lives, where it's going, how you're storing it, et cetera, et cetera. It's a good practice for compliance in general, but no other state privacy law has this explicit requirement to make this inventory. I hope you like the icons that I've added here too. Maryland has Old Bay seasoning and the old crab there. And Minnesota, it's the land of 10,000 lakes. So we have a little fishing icon and a Band-Aid icon for all the amendments that went into effect in 2025. So lots of, oh, thank you for the clap. I appreciate that. There were lots of amendments that were passed in 2025 that adjusted existing state privacy laws. So we had amendments take place for Connecticut, Montana, Colorado, Oregon, Virginia, Utah, Kentucky, and Texas. So for the most part, broadly, these amendments were focused around broadening rights around profiling and automated decision-making, increasing protections for minors. You're going to hear that be a increasing or a common refrain in this presentation. Protections for minors, children's data, that's become a real focus in recent years. Amendments also were focused on reducing, or in certain cases, certain limited cases, eliminating applicability thresholds, restrictions against geolocation, geolocation data processing, and updates to notice requirements. So all of those were, so all that's to say, these laws are living kind of documents, right? They're being updated over time and based on people's needs, especially as AI becomes more ubiquitous. Privacy laws weren't really designed to deal with the challenges that AI posed out of the gate for the most part, and they're being amended now to make that to make it more manageable to regulate AI rather than come out with specific AI regulations. So with all these amendments, you might think that things are getting more standardized a little bit, but not 100%. For the most part, actually, these laws are diverging in their particulars. So in terms of the standards that are converging among data privacy laws, requirements like PIAs and when they're triggered, those are becoming more standard over the data privacy landscape. Requirements for notice language, they're being made interoperable with other states' privacy laws. So Connecticut is a good example of that. Connecticut's law was amended so that you don't have to have a separate Connecticut law and a separate California law. They should both work with the similar language. And amendments have mostly aligned at this point consumers' rights offerings. So Utah now offers the right to correct inaccurate data. That was an outlier at the when it was first released to the public. In terms of diverging standards, the way that data privacy laws treat universal opt-out signals, that is differing. Some laws require you to honor those signals right out the gate, and other laws make no mention of them. If you're not familiar, these are essentially preference signals that you set in your browser rather than on the individual website. So if you want to opt out of all sales of personal information, you set that in your browser once instead of clicking 1,000 times every time you go to a different website. And regulators and legislators are kind of leaning towards that as a more user-friendly method of indicating privacy preference. As I mentioned, AI, automated decision-making, rights around those processes are being added to state privacy laws, but in a kind of lopsided way. So the right to question the results of automated decision-making technology is most apparent in Minnesota and Connecticut, and it's kind of not as clearly defined in other laws. definitions around what constitutes sensitive data. That's differing across pretty much every state law to one extent or another. And the standard for when consent is needed and what kind of consent is needed is, again, something that's different from law to law. So some require opt-ins for sensitive data or high-risk activities. As we mentioned, Maryland has outright bans on certain activities. So looking ahead, what is going into effect in 2026? What do you have to deal with in the future? I'm actually going to pass this over to TK to talk to us about data broker laws.
Thanks, Matt. Yeah, so we just wanted to cover some of the changes to state data broker registration laws. And I'll start with Texas, since these amendments actually went into effect in September. SB 2121 expanded the law's data broker definition, no longer requiring that an entity's principal source of revenue be derived from data brokering, while at the same time, it narrowed the law's applicability provision by specifying that its revenue thresholds are limited to just the revenue that the data broker derived from data brokering. So if you are on the cusp of Texas's data broker law before, you may want to reconsider these amendments to see if you're now in scope. And SB 1343 added additional disclosure requirements to the law's notice provision, which now requires data brokers to include information in their website or mobile app notice that they are currently having to provide, to include how consumers can exercise their rights under the Texas Data Privacy and Security Act, as well as include a link when they're registering with the state as a data broker, include a link in the registration statement to those consumer right instructions. And as for California, SB 361 amended California's data broker law to require significantly more disclosures from data brokers when you're registering annually, starting with their 2026 registrations. So these include additional data collection disclosures, as well as new sale and share disclosures. So now California data brokers have to disclose when they're registering with the agency whether in the past year they've sold or shared personal information to foreign actors, the federal government, or other state governments, law enforcement, or developers of Gen AI. And just to backtrack before getting into the new drop regulations, a California data broker is essentially an entity that buys and sells data without a direct relationship with the consumer. With that in mind, California's new data broker regulations went into effect January 1st. These regulations operationalize the Delete Act's accessible deletion mechanism, now known as the Delete Request and Opt-out Platform, or DROP. And as a quick overview, the DROP is essentially a one-stop shop deletion mechanism for California consumers that allows them to submit a single verified deletion request, which all California registered data brokers will then need to effectuate with respect to all of the non-exempt personal information that they hold on the consumer. So it's a lot easier and more consumer friendly to just go in and say, like, delete my data, and then it's just basically sent to all the data brokers in theory. And the drop went live January 1st. And California data brokers must create a business account and register through the drop as a data broker before the end of the month. And then starting August 1st, 2026, California data brokers will be required to start processing deletion requests every 45 days through the drop system, where they'll have to access the drop and download consumer deletion lists and then process those requests. And then every subsequent access to the drop, they have to update the status of the deletion requests, like whether they've processed them, whether information can be found, etc. And these regulations also clarify what it means to have a direct relationship with a consumer by not only removing the 3-year look back period, but also clarifying that a direct relationship requires a consumer to have intentionally interacted with the business. So the business does not have a direct relationship with a consumer simply because it collects personal information directly from them. The consumer must intend to interact with the business. And so a data broker or a business is still a data broker and does not have a direct relationship with the consumer with respect to any of the data that it sells about them, that it collected outside of that intentional first-party interaction. And I'll pass it back to Matt to discuss the updated CCPA regulations.
All right, thank you, TK. Yeah, we'd be remiss if we didn't talk about the CCPA. It's the kind of biggest, most significant privacy law in the US, and the amendments package that just went into effect at the start of the new year is pretty huge. So we've broken this down into 2 buckets here, new requirements and updated requirements. In terms of new requirements, certain businesses now have to conduct cybersecurity audits, really just a best practice, but the regulation kind of codifies it. I won't get into the word salad of whether or not of which businesses meet the threshold here, but we will be sharing these slides after the presentation so you can get into the details there. Additionally, businesses that have to conduct cybersecurity audits also have to submit an annual certification to the CPPA. Additional new requirements in the amendments package included changes related to automated decision-making. As I mentioned, lots of changes were happening to update these laws to account for automated decision-making, AI, profiling, et cetera, et cetera. So these requirements apply to businesses relying on ADMT, automated decision-making technology, to make significant decisions about consumers. Essentially, think about hiring, firing, approving for a loan, things like that. So businesses using ADMT for those purposes have to provide notice about their use of ADMT, offer consumers the right to opt out, offer them the right to access certain information about their use of ADMT, and the right to appeal ADMT decisions. And if you process the data of more than 10 million people, you have to disclose metrics on ADMT opt-out requests. So how many requests did you receive? How many did you approve? How many did you deny? That sort of thing. There are also new requirements around risk assessments. So any activities posing significant risk, inclusive of selling or sharing PI, processing the sensitive PI, which now includes the data of under 16-year-olds, more on that in a bit, using automated decision-making technology to make a significant decision about a consumer, certain profiling activities, training in ADMT, using facial recognition, emotional recognition, or similar technologies to verify someone's identity or profile them. Anytime you do something like that, you need to run a risk assessment or a PIA. Additionally, you have to submit an annual summary of all the risk assessments you conducted in the previous year and submit that to the CPPA. So in terms of updated requirements, as I mentioned, now under 16-year-olds data is considered sensitive PI. From my perspective, I think this is a pretty significant change. For one, because regulators are really focusing on children's data. Additionally, the Digital Age Assurance Act, which is going into effect in 2027, I believe, is going to cause a bunch of app developers to gain actual knowledge as to whether their users are children or not, or under 16 or not. Essentially, that act will ask OS and App Store developers to request users to add their ages in when they set up an account. And then if they do so, they have to pass that information downstream to the developers. So if you didn't want to know your user's age before, there's a certain amount of users whose age you will now know. And that will include, that will trigger the burdens associated with processing sensitive PI as a result. Additionally, mobile apps, connected devices, AR and VR devices have to meet certain transparency requirements. That's providing notices in an accessible place, offering rights before data collection begins. Additionally, you'll have to provide visible confirmation of opt-out preference signals. So the most common of those is the Global Privacy Control, or GPC. The image here on the left side of the screen, that's an example of what this might look like. So here in Osano, we have a little dot that shows up that says opt-out signal honored. Kind of makes sense if you think about it. If you're a consumer who's setting a browser side preference signal like you do with the GPC, you visit a website, you're not going to know if they've gotten your request and they're honoring it and actioning it as they're supposed to, unless there's some sort of indicator. Other amendments for the CCPA include the confirmation of the accuracy of sensitive PI that you hold. This can be kind of a security concern, but basically a consumer can call you, say, hey, you have my social security number. Can you tell me if it matches the number that I'm about to give you, right? And then you have to say yes or no. Obviously, there's a potential for identity theft there, so you got to be careful and make sure you're talking to the right person. Additional amendments are just kind of nitpicky ones, things like reinforcing the fact that you have to honor authorized agent requests, even if you require the data subject themselves to go to your website and verify their identity. You can't say, now that you're on our website, why don't you submit the request yourself? You have to still honor what the authorized agent is sending you. It doubled down on prohibitions against dark patterns. So you can't manipulate users into making one decision or another through design practices. That's what a dark pattern is. And clarified the exemption for insurance companies. So if you are subject to the California Insurance Code, you're still subject to the CCPA, but the data that you handle that is subject to the California Insurance Code is exempt. So it's the data exemption, not an entity exemption. Shelby and TK, I'm curious what you all think about the CCPA amendments. What's going to be the hardest for businesses to comply with? What's going to have the biggest impact?
They're huge. I mean, yeah, that's just my response. I'm just kidding. I think that the requirements around risk assessments, they're really detailed. You know, other state laws have requirements for impact assessments, risk assessments, but these new amendments require incredibly detailed risk assessments. You have to submit certifications to the CPPA. So I think that's going to be a really big deal. Obviously, one of the easiest check boxes for regulators to see is whether an opt-out signal is honored. So that's another biggie. TK, what do you think?
I actually was going to say the similar items as you about risk assessments and the fact that they also cover a lot of common processing activities, including like the use of third-party online tracking technologies. So almost everyone who's subject to the CCPA is going to have to be conducting these. And yeah, I think on the flip side of it, having that notification that you're honoring the opt-out signal is kind of low-hanging fruit, and it's an easy requirement to meet, especially if you have onboarded a consent management vendor, and worthwhile to prioritized since regulators can easily see whether you're complying or not by just visiting your website.
Yeah, definitely a lot to deal with there. And if California was the only state in the union with a privacy law, there would be plenty of work to do. But no, states keep on passing these dang things. So the newly effective laws as of 2026 include Kentucky, Rhode Island, and Indiana, which you can remember with the handy acronym RIK, R-I-K. I have them out of order here, but that's the way I've been thinking about it. So I won't go into the huge amount of detail here. For the most part, they kind of map to the general structure of other data privacy laws, but there are a few features to take note of here. So this whole group of data privacy laws does not have a universal opt-out requirement. They don't mention them. I would honestly expect that to change at some point down the line through amendments. Even if not, you're probably going to want to be able to honor those. And if you use a CMP to manage consent, it's going to have the support to honor universal opt-outs. So just something to be aware of here. Kentucky is a little bit unusual in the sense that it defines the sale of personal data as being for monetary exchanges only. Most privacy laws also include or for valuable consideration. So targeted advertising is a great example of valuable consideration, right? You're sharing consumers' data. They're giving you the leads from targeted ads. Money isn't necessarily changing hands in all arrangements there. Oddly enough, Kentucky also calls out targeted advertising as still being subject to opt-out requirements. So there is just the potential for other valuable considerations that are going to slip through the gaps with Kentucky. As I mentioned, it has a pretty standard set of PIA requirements, which we're seeing shape up in a similar fashion with other state privacy laws. So you explicitly have to conduct them for targeted advertising, sales, profiling, sensitive data processing, and other, high-risk processing. That's the catch-all. That requirement does not kick in until June 1st of this year, though. Lastly, Kentucky has a non-expiring cure period. So that doesn't mean that you can put off all compliance until you get an angry notice from the Kentucky regulator. There have been a few enforcement actions in 2025 where companies were notified of their non-compliance and were not able to fix the issues in that cure period. So it's really intended to plug gaps, to address accidents, not to, go from 0 to 100 once you get that notice. For Rhode Island, also no universal opt-out requirement. It has some fairly unique privacy notice requirements. All websites that serve Rhode Islanders have to have a privacy notice, not just above threshold websites. Additionally, it has to list all the third parties you're going to sell or the controller is going to sell or may sell personal information, which is a little bit of vague wording there in the statute. Again, PIAs are pretty standard as for the other privacy laws that you've seen, and no cure period for Rhode Island. Indiana is probably the least interesting of this crop. It's just no universal opt-out requirements, standard PIA requirements, and a non-expiring cure period as well. All right, I'm going to pass it over to Shelby to talk about enforcement.
Yes, I get the scary topic, as Matt called it earlier, but I do want to focus both on takeaways from 2025 and what to expect in 2026. This is a big topic. I frequently get asked by clients, what is the risk associated with compliance? And this is the risk. Enforcement is one of the risks associated with compliance. So I'm going to take time today to dig into this. In order to all start on the same page, U.S. data privacy laws provide certain agencies with the authority to enforce the law. However, it can differ slightly. For the majority of state enforcement authorities, it's going to be through the AG's offices. But we do have states like Texas that have a specific investigator unit within their AG office, And then we have California, unlike any of the other states, where the CCPA can actually be enforced both through the AG's office and the California Privacy Protection Agency, which is one of the reasons we see so much enforcement here. In many cases, we often see AG offices using some of their traditional consumer protection and unfair and deceptive trade practices authority to bring claims in conjunction with violations of their consumer data protection laws. So often when we're reading through a lawsuit, it's going to contain claims under multiple laws. So despite these differences, we are seeing more coordination among regulators. So for example, in April, it was announced that 8 state regulators, including AGs from California, Colorado, Connecticut, Delaware, Indiana, New Jersey, and Oregon, and the California Privacy Protection Agency, were going to form a bipartisan consortium to collaborate on the implementation and enforcement of these laws. And then in October, we actually had 2 more states, Minnesota and New Hampshire, join. So we do have regulators collaborating. And this really isn't surprising. If you've been in the data privacy space, then you know that we often see coordination in the data breach investigation enforcement. So again, I expect to see more collaboration this year. Let's start with some of the enforcement actions in 2025. In total, we had 7 enforcement actions under consumer data privacy laws. If you are keeping a close eye on enforcement, maybe you think I'm miscounting, but I'm not. The action brought against an insurance company under the Texas Data Privacy and Security Act was actually dismissed in April due to a jurisdictional issue. So that makes the number 7. This list also clearly doesn't cover any privacy adjacent actions, those under data broker laws or deceptive trade practices acts, like I mentioned earlier, which we did see this year. But clearly the number 7 doesn't apply to that. It only includes violations of consumer privacy laws. Okay, so in 2025, we had the first lawsuit filed under the Florida Digital Bill of Rights, and it targeted a streaming service provider. And I'm going to dig into this a bit more, but we did also see the first lawsuit come from Kentucky. And technically that's 2026, but it's such a big deal that I kind of wanted to include it on this slide as well. But I'll dig into that in a little bit. So what can we learn from these 7 enforcement actions this year? The 7 matters involve different regulators, but together they all do highlight several reoccurring themes that we're seeing, and a lot of which Matt's talked about already with some of the new laws and amendments. So first are third-party advertising and analytics. Regulators have consistently looked at how companies collect and share data with third parties, especially for advertising and analytics, including through the use of cookies and tracking tech. So this involves taking a close look at your cookie management tool and ensuring that it works correctly and that it aligns with your privacy policy. Another piece of this is checking that your cookie banner, it's transparent. It doesn't have any dark patterns. For example, if a consumer presses an X on your cookie banner, does that mean you take that as consent and just automatically start allowing all cookies, or do those cookies stay turned off? Those are some big pieces that we've seen around litigation if you've kept up in that space. So these are all areas that regulators can easily check on a website, and they are doing so. The second is transparency. Regulators always look at whether privacy disclosures are accurate, prominent, understandable. Do they comply with all of the applicable requirements? I often explain to clients that as a public policy, this is going to be an easy checkbox for a regulator. They can have a little checkbox and they can go through your policy and see if you meet all of the requirements under their law. So you really need to understand what laws apply and what disclosures must be in that policy. And also, update your policy. California has an annual update requirement. So it's a really easy sign for regulators if they go to your privacy policy and it hasn't been updated in 3 years. They're going to know that's going to be an issue because data practices do change. So make sure you're taking a look at it every year. Third is sensitive data and the treatment of that data. So this has been another big issue for regulators. When I say sensitive data, I'm talking health-related information, precise geolocation, children's data. This data is viewed as more high risk and state privacy laws often treat this differently than other data, some requiring opt-in consent for the processing of that type of data. And as we were touching on earlier, some requiring risk assessments if you're going to process sensitive data. So this data is also scrutinized heavily when it's used for targeted advertising and being shared with third parties, which again goes back to my first point about advertising and analytics. So, if you're following along, this all goes together. And then fourth on my list are consumer requests. It's really important to have a process in place for responding to consumer requests, because this is an area where regulators receive consumer complaints. This includes both your opt-outs on the websites, for your cookies, your targeted advertising and sales, but it also includes your request to delete, access, correct. If you've ever received a request, you know that you want to figure out how to respond to that well. If you're responding to it incorrectly, or maybe a little snarkily, that can result in some consumer complaints. And so we often actually refer to it, responding to consumer requests, as both a legal obligation and just another part of customer service, because you really want to keep that customer happy to avoid any complaints. Okay, so let's talk about California again. On this slide, I'm sharing a chart that the California Privacy Protection Agency shared in a meeting back in the fall. This chart highlights California privacy enforcement. So if you can see, since July 2023 to September 2025, the CPPA has received over 8,000 complaints under the CCPA. If you look closely at the chart, you'll see that the complaints really climbed steadily over time, and then there was a noticeable inflection in early 2025, where the slope starts to get steeper. So visually, you can see that it isn't one or two big spikes, but sustained growth in consumer complaints, with a real surge as we moved through 2025. So let's talk about dollar amounts. I saw some questions in the chat about how do I convince my C-suite that this matters? Dollar amounts, put these figures in front of them. See if this starts to speak their language. With California enforcement, the average fine is about $850,000. And for many organizations, that's not going to be a rounding error. So, put that on a slide when you have your next meeting with the C-suite. At the low end, the smallest penalty out of California was $85,000, and at the high end, there was a fine of $1.55 million, and that was after remediation. So just to keep in mind. Okay, on this slide, I want to move kind of from those numbers with California to some other notable enforcement developments. Again, I'm starting with California, lots of California talk. The first is the CPPA action against a rural lifestyle retailer that resulted in a $1.35 million fine. This is the largest fine from the CPPA that's been issued to date. Remember, the CCPA can be enforced by either the CPPA, so many acronyms, or the California AG's office. So when I say it's been the highest fine, it's been the highest fine from that enforcement agency. So from a benchmarking standpoint, this is a new high watermark for that agency. This enforcement action was the first time that we've seen rights for job applicants be enforced. So up until this enforcement, the focus has been on customers and website visitors. It's important to remember that the CCPA applies to consumer data, employee, job applicant, and B2B data. So enforcement agencies have the right under the CCPA to look at all of your data practices. The order also requires annual executive certifications for a period of 4 years. So that means that leadership, not just the privacy team, must formally attest that the company is complying. It effectively puts the C-suite directly on the hook for the company's data privacy compliance. Finally, the CPPA's review, in this case specifically, tracked all the way back to early 2023 when their enforcement first began. So even though we didn't see a penalty until 2025, the agency was looking at contact going back to the very start of its authority. So that's an important reminder that unless the law states otherwise, when new laws go into effect, enforcement agencies may later reach back years when they finally do bring a case. Okay, so let's move on to Kentucky. Like I mentioned earlier, just last week, 8 days into the new year, the Kentucky AG brought a lawsuit against an AI chatbot company for violations of the Kentucky Consumer Data Protection Act, among other violations. The case is notable for a few reasons. First, it has a strong AI and children's focus. The complaint alleged that the platform's features were unsafe for children, and the defendant failed to implement effective age gating, parental consent, and identity verification mechanisms to prevent children from under 13 from accessing the platform or interacting with chatbots. In its announcement with the complaint, the AG emphasized that the US can be a leader in AI, but it can't come at the expense of kids. So Kentucky is one of the first states that they're saying they're taking a stand against AI, as well as still having a focus on children's data. And these are two areas that I expect to see more of in 2026. Second is the KCDPA includes a 30-day cure period. So as many of us know, some of these laws have had rights to cure. And given that the law went into effect January 1st, 2026, it appears that the company was not given 30 days because the AG's office brought a lawsuit 8 days after it went into effect. The AG only sought injunctive relief with its complaint, but I just think this is really interesting. I don't know how they have the authority to do this, and I'm really interested in seeing how the court's going to treat this issue. So something to consider. Lastly, I want to touch on smart TV focuses. We had Florida, Texas, and California all bring enforcement actions against smart TV providers. Texas actually targeted the manufacturers, and this wasn't under the consumer law, but under the deceptive trade practices law. And they really were, if you take these all together, sending a pretty clear signal that regulators see the connected TV ecosystem as one of those spaces that they're going to regulate. And you can see this translating into other smart devices. A big issue under all of these lawsuits were the handling of children's data. So again, this topic just keeps popping up. Okay, lastly, these are just some of the trends I think we're headed to in 2026. First, like I've talked about before, consent management or your cookie management tool. I don't think that having a bare bones tool anymore is going to cut it. Regulators are looking for gaps. They want to make sure that you have opt-out mechanisms, that you're recognizing the GPC signal, that you're eliminating dark patterns. We're seeing an increase in litigation around cookies and tracking technologies. So if you can mitigate this risk for compliance, you're also going to mitigate this risk with litigation. So it's important to approach both equally. Second is artificial intelligence, AI. We couldn't go an entire webinar without talking about AI. I always make that joke, it's so silly. But jokes aside, as we head into this next legislative session, we expect to see many state regulators propose AI bills. The Kentucky case is an early example of how a consumer privacy law applies to AI and how we are likely to see a focus on consumer-facing AI services and those used by children. And then third is children's data. I could go on and on about children's data. We have a bunch of new laws in the system. It's becoming a really big patchwork, and I encourage all companies to re-examine whether they're collecting children's data. And remember, this doesn't just mean under 13 anymore. This means under 18, because many of the state privacy laws, I think 10 in total, apply to the processing of minors' personal data. Okay, I'm going to hand it back over to, actually, one last point. Sorry, I know I'm a little over time on my piece, but I want to highlight that 2026 is an election year for AGs, for many AGs. And so I do predict that we're going to see popular investigations, either bipartisan investigations or types of investigations that are strong with their base. And I think we're going to see some quick investigations. But that's just a prediction based on it being an election year. So, okay, now TK, if you want to talk about data brokers.
Yeah, I'll try to run through data brokers real quick, just hit the high points, but we're definitely seeing more attention being spent on data brokers, especially in California. Back in November, the agency launched a dedicated data broker enforcement strike force, And just last week, they announced the strike force's recent round of enforcement actions from December. So we're definitely expecting that to continue, if not ramp up. And it's something that entities, if you are a data broker, should really keep in mind and prioritize, because the penalties, the fines in California could be substantial. It's $200 a day for failing to register, but where it might put a dent in your pocket is the penalty for failing to comply with deletion requests. It's $200 a day per consumer. So every day that you're not registered, not, accessing the drop and actually processing and complying with those deletion requests, that adds up for all of the California residents who have signed up to delete their data. So could be substantial, and just wanted to flag that.
Okay. I know we are getting close to the end of the hour here, so I am going to zoom through these slides so that we can at least answer a couple of questions. We'll be sharing this slide deck after the webinar, and we'll additionally be drafting a blog post answering some common questions or common question threads for the, I can see there's lots of questions here that we're not going to be able to get to in time, but we'll do our best. I hope you all are ready for the fastest set of slides you've ever seen in a webinar. So don't assume your consent management is compliant in this new year. Regulators are probing for gaps. It's easy to test to see if you're compliant. You should be testing your cookie consent as well, especially for GPC and universal opt-out signals. Check on the back end to make sure all cookies and trackers on your website are classified. Don't just assume you're compliant because you have a tool in place. Double down on assessments. Lots of requirements around assessments this year. If you do any, if you're starting a new initiative and it involves sensitive data, targeted advertising, selling or sharing personal data, profiling or automated decision-making technology, or a general heightened risk to consumers, or if you think maybe it might involve any of these, run a PIA just to be safe. We have some suggested areas to cover. Most laws don't have prescriptive requirements for what to include in your privacy impact assessment. The EU, though, does for their DPIAs. So if you go to the EU, any DPA, Data Protection Authority in the EU, they'll have some guidance on what to include in those assessments, and they're rigorous enough that they'll meet the standard you need for most U.S. state privacy laws. California also has more prescriptive guidance relative to other state privacy laws. And then lastly, build a response plan for if you get a notice from a regulator. Have something in place. It'll make you feel a lot more calm. I'm obviously not going to run through all of this. We have kind of a draft, bare bones, high-level response plan on the right of this slide. And while privacy-specific incident response is maybe a relatively new thing, incident response as a whole isn't. So check out established frameworks like NIST CSF, NIST Special Publication 861, Revision 3, ISO IEC 27035. Okay, so I know that was very fast. I apologize for the wonky timing here, but we're going to jump into some Q&A. And I wanted to start with a subject that we didn't touch on too much over the course of the webinar, which is developments associated with California Invasion of Privacy Act, BPPA, wiretapping acts. We have a few questions about whether there are any new developments there, or if it's the best idea is to take an opt-in approach to consent. So from my perspective, opt-in's always just going to be a safer bet, but your marketing department is going to be very sad if you really advise for that. So there's going to be some push and pull there. It is going to protect you way more against these lawsuits. New developments, Yeah, they're still happening. There's businesses are still getting hit with these. Legislators and courts are getting upset, I guess, to an extent, that these old laws are being repurposed. But regardless, their businesses are still getting hit with these complaints. Shelby and TK, I'm curious about your perspective on this.
Yeah, we have a whole litigation team that handles these types of complaints we're getting for our clients. And yes, it's not stopping. I was just talking to the partner right before this webinar about how the newest thing that they're seeing is that your cookie banner, if you opt out, you actually have to opt out of all your cookies, or you could have a claim against you, which seems like something easy to do. But as we all know, if you've dealt with a cookie management tool, there's a lot of steps to it. As Matt knows, as an Osano person, that configuring your tool really matters. So take another look at it. I don't see any near end to that type of litigation.
Yeah, it's regarding cookie consent tools. Some tools are going to be more or less maintenance over time, but there's always going to be a little bit of ongoing auditing you have to do there. I would be remiss too if we didn't plug a webinar that we're going to be conducting at Osano on February 5th regarding SEPA and how to configure Osano specifically to reduce your risk there. So we'll include the registration link for that in our follow-up materials as well. I also wanted to ask this question about enforcement. So given that California is the only state with a dedicated enforcement agency, do we expect that other states are going to lag behind California since other states rely solely on the state AGs? From my perspective, you might remember I mentioned how state AGs are working together. I think that means that you're not going to see as much of a lag or less risk to your business if you're not in California, right? They're all kind of sharing knowledge. What do you all think?
Yes, absolutely. I sat on a panel at the IAPP's PSR conference back in October with some regulators, and definitely, Texas has a strong investigator unit, so we are going to see enforcement from Texas, and then those regulators who are in the consortium, they speak a lot about regulating, and so I think even the smallest of AG's groups, for example, Indiana's law just went into effect, but they were talking about how they were already ramping up for enforcement, and they're a small group, so I expect to see some players for sure. I don't know if any of them will ever be to the extent of California, just because they have two agencies, but I wouldn't not expect to see it from others.
For sure. Let's see here. I think we have time for one more question. I will actually pose this to you, TK and Shelby. I'm not super tapped into this at the moment. Regarding the Colorado AI Act, that's the US's kind of big AI-specific regulation. What's happening there, and what's the overlap with data privacy?
So we expect amendments to it. They were trying to pass amendments last year, and they did not make it through. And there's been a lot of pushback against the Colorado AI Act. Also, Trump did pass an executive order withholding money from states that try to enforce their AI laws. So TBD is my full answer.
Yeah, that's what I've seen as well. I know there's been some back and forth on that, and I believe there was some news recently about the DOJ putting together an anti-state AI regulation task force. So yeah, it's kind of up in the air, but we'll keep you posted on any developments there, especially as they relate to data privacy. And I just want to thank you all for attending this webinar. I want to thank our friends at Troutman, Pepper, Locke for coming in for the three-peat. And hey, maybe we'll see you again next year.
Thanks, everyone.
Bye.
Thank you.